this is a real thing, but what I learned about it was that under that False Claims Act, the federal district court has national subpoena powers, which is a very unusual feature. So the judge presiding over that court issued a subpoena to my guy in South Carolina, and he had to go to Virginia to testify. So I learned a lot about key times and false claims that I never knew before. Our last speaker this afternoon is also a partner in Nelson, Mullins, Riley, and Scarborough, and he's in our Charleston office. He and I have become good friends. We're on some joint task force for corporate governance and internal investigations and things of that nature. But Bryan is a Kentucky-educated fellow. He went to the University of Kentucky to undergraduate school, as well as to law school. And Duke and Kentucky used to be arch rivals, but I don't hear y'all
Kentucky
mention
doesn't play basketball anymore. They don't play basketball. They got out of that business.
But Mike focuses his practice on corporate governance and securities and things of that nature, and I thought it would be great to, he's also does a lot of ethical advice to companies and to company general counsel. So this hour has a little ethics spin to it, so we can get an hour of ethics credit. So I will turn the program over to Mike. One thing though, I think it's important for all of you to know that he spent a fairly long time, 6 or 7 years, as Assistant General Counsel for the Monsanto Corporation in their corporate governance. That's what he did, advising them on corporate governance. So he's quite a learned guy in this field. Mike?
Thank you, Judge. Happy to be here. Sorry I sort of blew in at the last minute and didn't get to hear but about 10 minutes of the earlier program today. I have the book, and I actually would like to ask some questions about the sentencing guidelines for some things I'm working on. As Judge Cox said, I don't do criminal law. I do advise corporations and boards and so forth. About 2/3 or 3/4 of what I do is with public companies, and I try to keep them from having to worry about any of this stuff. And so obviously we get into this area and we get into the realm of getting close, or too close for comfort maybe sometimes, to the criminal side of things. What I would like to talk about is really the not necessarily that new, maybe the last 2-3 years, focus on lawyers by primarily in my talk today, at least primarily the SEC. I guess a little over a year and a half ago, the then head of enforcement, Stephen Cutler, gave a talk that has become known as the gatekeeper speech. I don't know how many people are familiar with that. If you do work for public companies, or if you just stay up at night worrying about things, it's one of those things that will enhance your worry when you read this, because part of the tone of the thing was lawyers are gatekeepers. That's been around for a long time, but this was his warning or his message to everyone that the SEC had renewed its focus on gatekeepers and was squarely putting lawyers in there with several other groups. I heard Stephen Cutler speak about maybe 6 or 8 weeks ago at a conference in San Diego. He's now back in private practice, and he's changed his tune completely. He thinks that the SEC was way out of line, and they were really going overboard, and really this is it's really just way too much. But he kind of started the ball rolling, and I don't think that it's like Sarbanes-Oxley in general. No one wants to be the one who decides it's time to back off a little bit because it doesn't play well in the headlines, even if it is the right thing to do where things got carried away. So I want to talk a little about Sarbanes, but not a lot. Sarbanes, people talk about the Sarbanes-Oxley Act as if it is a sort of a discrete thing. It's not even an amoeba. It's more like an octopus. It's basically the biggest set of amendments to the securities laws since 33 and 34, since they were enacted, basically. So it gets its tentacles into all pieces of it. Disclosure in particular, accounting rules, certifications by officers, everything you can think of. And one of the notable things that they added that comes out of Sarbanes-Oxley in the Act itself, there's a provision that required the SEC to prescribe standards for lawyers, which the SEC did in a rule called Rule 205. Now, I don't want to spend a lot of time on that today, but the rule does dovetail with, I won't say it conflicts with or works well with, it's okay with the state laws for what lawyers representing organizations need to do. And so I want to focus a little bit on that to set up some of the things, and then I want to talk about some of the headlines that we've seen over the last couple of years. One thing that a lot of people who don't practice in this area of securities law don't realize is that this Rule 205, it applies to lawyers who are appearing and practicing before the SEC. And I cannot tell you how many litigation lawyers I've had say, okay, I don't need to hear about this. That's not me. I don't do that. And I'll say, well, you do environmental work, right? Well, sure, that's all I do. I'm not a securities lawyer. Well, do you do environmental work for any public companies? Well, sure, yeah, 7 or 8. Well, have you ever received an email from an in-house lawyer at the public company saying, take a look at this paragraph. It's the one we used in the last 10Q. Have there been any changes in in our deal with the EPA? And they update it. And I said, well, yeah, you just appeared and practiced before the SEC. The SEC has a very broad definition of who appears and practices before it. And that is anyone who actually deals with the SEC. Say you're doing a registration statement and you're taking comments, but it's also anyone who prepares anything that they reasonably ought to know is going to be used in a filing. It's going to be furnished to the SEC as opposed to filed, or it's going to be, and there's a little debate on this interpretation, or it is used in a decision not to file or furnish something. So anytime you're dealing with a public company, you might be appearing and practicing, even if you're not doing anything whatsoever to do with securities law per se. So it's something to keep in mind. People don't really, it's not one of those things you would know just reading the title. Just very, very generally, very basically, what the rule does is it requires lawyers to report up the ladder. Everyone's heard the report up the ladder, and then, of course, the term noisy withdrawal got a lot of discussion, and when the rule came out, it was proposed initially. But what it requires lawyers to do, and this is, again, lawyers who are appearing and practicing before the SEC, if they become aware of something in connection with representing an issuer, a public company, and again, we can get into all kinds of minutia about what it means to become aware of it while you're representing them as opposed to while you're doing a deal with them and that sort of thing. But it requires you, if you become aware of it, to report material violations of securities laws, breaches of fiduciary duty, or other similar laws, state or federal. Obviously, the third category is fairly broad. There is a somewhat Byzantine set of rules for how you report up and to whom. If they have something called a qualified legal compliance committee, you may report to them. You may report to the CEO, the general counsel, the audit committee. There are all kinds of different pieces for how you do that, and there's a structure for that. But it's just, remember that what we've got to do is, if you become aware of these things, you've got to report up. Now, you may be working on something, and it may come up. It may be very clear to, say, the general counsel or the in-house lawyer that you're working with, that something that everyone has become aware of it within the company, or all the lawyers working on it. In those situations, you have to ask yourself, is this the right person? Is this person that I'm working with the person to whom I would have to report this if let's say, it just came to me out of the blue and didn't come through this lawyer? So you may get into a funny situation where you're working with someone who's not the general counsel, and you may have to say to them, look, this is kind of silly, but I need to send this to the general counsel. Let's send an email together. Let's do this together, whatever. So that, I've had to report up one time, and I can tell you, when you call a client up and you call the general counsel and you say, well, I never thought I'd have to do this, but I have a Rule 205 report to give you, they don't like it much. So it's a delicate situation, even though it could be for their own good. But it can be tricky. So dealing with the technicalities of the rule in the real world kind of gets tough from a client relations standpoint. This is one thing I want to focus on as we get to some of the headlines. The rule has a provision in it that basically says the same thing as the model rules and so forth. If you represent an organization, you owe your duties to the organization, not to the officers, directors, any other employees, or to the shareholders. The proposed rule actually had something about shareholders because there's some old SEC thinking that says you owe duties to shareholders because they're the owners and so forth. But that actually contradicts with most state law, that you do not owe the duty to the shareholders or the owners, you owe it to the entity. And so that gets kind of tricky, and when you really think about where some people get themselves in trouble, it's mostly because, well, I shouldn't say mostly, but it's often because they're thinking more about maybe usually executives or potentially maybe a very large shareholder who controls things and really has a finger in the pie than they are the entity itself. So I just want to touch on that and the ABA model rule about representing an organization. Again, same concept that you represent the organization, not any of its constituents, as it's referred to in the model rules. But also there is a reporting up provision in the model rules that says that if you know of something that is likely to result in a substantial injury to the organization, you are to, and I quoted from the rule, proceed as is reasonably necessary in the best interest of the organization. And you're left to your own devices to figure out what that is. But if you're appearing and practicing, you'd hope that you'd try to dovetail that with Rule 205 and do it that way, and that's in the best interest of the organization. Maybe it is and maybe it isn't, depending on your facts. This is the gatekeeper speech from Stephen Cutler. He had three themes: that the significance of gatekeepers, maintaining integrity in the investigative process, and that one really, we'll come back to gatekeepers, but the second item really had to do with the SEC seeing issues arise in situations where organizations had gone out and undertaken an internal investigation in order to deal with something that they had uncovered or that had been brought to their attention by maybe regulatory authorities. And obviously, you get the headliner, so and so is going to investigate. We'll get to the bottom of this. You make a big fuss about, thorough investigation, and as you see in the newspaper, some of those investigations are more thorough than others. The SEC is concerned and was and remains concerned that some of those investigations are a little more self-serving than maybe they ought to be. And then the third theme or third piece of that speech was greater personal accountability. And the SEC, starting with that period of time and since then, has been careful to say that includes the lawyers, not just CEOs and CFOs. As everyone is probably familiar, under Sarbanes, CEOs and CFOs are certifying financials, both under a civil certification and under 906, a criminal certification. Those two are sort of drafted during the same period of time at 4 a.m. on a Saturday morning by two different committees, and they both got in the act, and there they are. And they're different, but very similar, and you sign them and you certify. And if you can't certify, you shouldn't be filing your Q or your K or whatever it is, and you've got a problem. Now, some would argue, and I think I'd be among them, that the CEOs, CFOs already had the responsibility that they're signing on for, signing those, but I would have to say that in my experience, I have seen it help some. Some people don't like signing things. Some people think about something when they pull out that pen and they're ready to sign that certification. A lot of it has resulted in a lot of procedural policies being put in place about sub-certifications and so forth. But I think by and large it has had some beneficial effect. It makes people at least stop and think. And as I think I saw I think it was in an article not too long ago, talking about Bernie Ebbers, it said that at least it should stop people from being able to take the approach or make the argument that I'm a big picture person, I didn't know anything about that. If he had signed those certifications, it would have been a little bit harder to say that. Now, it didn't do him any good anyway, but I think that's the idea, and I think it has had some beneficial effect. So the SEC is very clear that lawyers are among these gatekeepers. And I believe there's some, in some of the congressional hearings, I believe there's some of this sort of where were the lawyers ringing out when they were looking into Enron and so forth. There has been, this just talks about the fact that there's been, I think in a couple of years, ending maybe a year or so ago, there were about 30 lawyers named as respondents or defendants in SEC enforcement actions. I think that was way up from the couple of years prior to that. I want to hit a few of the headlines from the last couple of years and talk about how the SEC and maybe some others are approaching holding lawyers responsible either as gatekeepers or as primary violators or both, or who cares, we'll just get them in there, basically, is how it ends up in a number of cases. Ira Weiss was a fairly recent, I think last December is when this one came out. He was acting as bond counsel. I don't know how many of you are familiar with tax-exempt finance, but it's a very specialized role, very specialized practice. And bond counsel's role is to give an opinion, a completely unqualified opinion that really goes to two things. The bonds, the interest on the bonds will be exempt from federal income taxation, and that the bonds are validly issued debt obligations of the political subdivision that issued them. It's a very, the opinions have become very standardized. The rules are somewhat Byzantine, I think, for determining whether something is tax exempt. And apparently, Mr. Weiss was a little bit cavalier about determining this. It appears that he did a very minimal diligence, was not all that familiar with the rules, and when it came down to some of the primary requirements for these notes, these were just 3-year notes issued by a school district in, I think, Pennsylvania. He did only cursory diligence. And on some of the very most important points, he sort of glossed over it with vague representations in meetings and so forth, and didn't actually sit down and ask the hard questions. Now, you have to ask yourself, and the SEC, I think, said that he was at least negligent. When you read this order, he was. You think he was at least reckless, and I mean, it was you know, the guy was on vacation the whole time. Now, it could be that, you know, someone said at a conference I was at recently talking about this, it was a cease and desist and disgorgement, and he had to disgorge his entire fee plus interest, and it was something like $9,600. And somebody said, well, he did all the work he could possibly do for $9,600 on a bond issue, but, you know, maybe he signed up for a low fee, fixed fee, and just had to cut it close and try to get it done quickly. But I think this one is somewhat troubling if you think about it, because you wonder if he was just negligent, why did the SEC bother to go after him? He signed an unqualified opinion. He reviewed what's called the official statement, which is the disclosure document under which the bond, pursuant to which the bonds are marketed to the purchasers, that described his opinion and probably had his opinion attached. And he signed off on that. So it was anti-fraud provisions under which they went after him. And said, basically, you knew this opinion was going to be circulated to the purchasers. You knew that the disclosure document obviously was designed for that purpose, and you let it go without doing even, you know, I was a bond lawyer for 12 years, and I read what this guy did, and I couldn't believe it. Even minimal diligence as to the expenditure of the proceeds and so forth. The issuer was only vaguely aware of the rules that it was subject to in issuing these notes. And that's a theme that comes up in some of the more recent SEC enforcement actions, is that the lawyers and the clients aren't talking enough. The lawyers don't, the SEC seems to be saying that the lawyers are not telling their clients enough about the risks of what they're doing, about how hard an opinion this is maybe to give. And as I say, in a bond issue, it's either an unqualified opinion or it's no opinion at all, and you don't do the deal. There's no such thing as a reasoned opinion in these deals. And so what he had to do was he had to decide whether he could give that unqualified opinion. According to the order, he gave had no discussion with the issuer about the fact that that he could just barely get to the point of giving that opinion. They didn't know what the requirements were as far as expenditure of the proceeds of the bonds, investment of the proceeds, identification of projects that would be at least equal to the bond proceeds, and they kept coming back to this. I was at a seminar recently where there were some SEC enforcement staff members, and they kept coming back to the fact that he wasn't communicating with his client about just how risky this was. And we'll get to this. I think it's on the next slide. but that seems to be a recurring theme. The lawyer not telling the client enough for whatever reason. Maybe he was too busy. Maybe he didn't want to spend time on this because he only had a $9,600 fee riding on it. That's all he could get out of it. Or maybe he thought he didn't need to do it. It's hard to say, but the lawyers almost step into the business role when they do that. And I think in this one is when we really see this happening. I don't know if any of you are familiar with this. I think this actually came down about I want to say the beginning of 05 maybe. This was before the Google IPO. Google issued tens of thousands, hundreds of thousands of options, stock options to its employees prior to its initial public offering. And when you're issued, a stock option is a security. And so these securities either had to be registered under the 33 Act or are exempt from registration. There's some registration exemption. There is a registration exemption that is typically used by private companies. This is before they were public, by private companies called Rule 701. That requires you to give all kinds of financial disclosure to the recipients of the stock options. And these people were receiving these as compensation, but they're still issuing securities to them. Google issued lots of options to virtually all of its employees, and sometime over a period of about 2 years, the general counsel, David Drummond, thought about this and decided that maybe he ought to look at whether they what they were doing about the exemption, and apparently hired outside counsel, looked at it himself, had outside counsel look at it, and it's hard to say if a determination was made. The order is very carefully worded to not say a lot of things, but leave a lot between the lines. He apparently decided that it was at least very likely that they had no exemption available for the issuance, probably of the options that they'd already issued at that point, but certainly options going forward. And so apparently what he did was he told outside counsel, thank you very much for your help. I appreciate it. I'll let you know if I need anything else on this. He apparently decided, he thought about it himself and decided that maybe they could use another exemption, 4.2, the straight statutory exemption for a private offering, but wasn't so sure. But he went to the board and presented papers and assisted the board, as the general counsel would do, in approving numerous additional stock option grants to hundreds of additional employees, thousands and thousands of additional stock option grants. And this went on up till right near the time they started working on the IPO. Now, apparently, he decided in the course of his investigation or analysis of all this that the primary remedy for this would be a rescission offer to the employees for issuing unregistered securities. That would be one of the first steps you'd have to take, is to offer to buy them back. And so what's between the lines is that it appears maybe he decided that's what he would do. And so Google goes public, and if you remember, about the time of the IPO, it came out that they had all these unregistered options. And so this is the order. The SEC goes out of its way in the order in this one to say that the general counsel, David Drummond, took this decision on himself. He became the business person. He didn't even tell the board that there was an issue with registration exemptions. Didn't hint to them that there was anything risky about this, and it was at least risky. I mean, it was probably much riskier than the order even would say in black and white. And he got out of it with a cease and desist order, which is a bit amazing, I think. And I suppose they thought that the reputational damage would be punishment enough, but this was a pretty blatant case of looking at it and saying, oh, what the heck, these are issued at 16 cents when we're at $160, who's going to rescind? And of course they didn't. They did a rescission offer, and to my knowledge, no one, maybe 2 or 3 estates or something, rescinded. So the SEC found that he caused the violation, that he was actually a primary violator here. And they went out of their way to go after him, but they only gave him a cease and desist, which I thought again was a light outcome. But I think they thought that we're going after lawyers. This will send a message not only to him, but it will send a message to all lawyers. And again, at this seminar with the SEC enforcement people present, they were very clear that the problem they saw here was that he wasn't communicating with his client. He wasn't saying, okay, here's how it looks. This is we've got this end of the spectrum and this end, and we're somewhere over here. I would advise that I can tell you we're close to the line. He wasn't giving the client the option to make a decision based on an informed legal analysis. He was making it for him, and that was one of the things they came back to. And they said, you can leave here worried as lawyers that your decisions are going to get you in trouble, and you're going to find yourself at the wrong end of an SEC enforcement action if you are not acting as a lawyer. If you step into the shoes of a business person because you simply take it on, either because maybe who knows, was it a prior mistake? Did they miss it the first time around and didn't want to admit it, or did it just seem like sort of the run and gun thing to do at the time? It's hard to say. No one knows, but clearly they thought that that's what he had done. This last bullet, I think, sort of sums up the way. I think that was a quote from Stephen Cutler. Can't just make a decision to violate the law. And again, if you look at some of the analysis, it says, well, all we have to do is do a rescission offer, and it appears it could have been a decision to just go ahead and do it anyway. Lucent is a situation where it was a securities fraud action against Lucent and several executives. This was Lucent, if you remember this one, Lucent was getting close. They had an agreement in principle on a settlement, and the outside lawyer, and I think it was the CEO, did a Fortune magazine interview in which the outside counsel said that the fraudulent booking of revenue was nothing more than a failure of communication. Well, that didn't sit too well with the SEC. And I put this on just as an illustration of how, again, the lawyer's stepping outside the role of lawyer here. What's the lawyer doing in Fortune magazine, trying this in the magazine sort of thing? He's trying to be a celebrity. And so stepping outside the role of lawyer, and it ended up getting Lucent a lot bigger fine than it was going to get, a whole lot bigger. And the SEC characterized this as a failure to cooperate. There were a number of things. Apparently, the lawyers were slow to produce things. They'd forget them, and they'd forget they had them, and they'd say they couldn't get them, and then when they were told they had to, they'd find them in a day. And there was a lot of this. There was a lot of other types of failure to cooperate going on. Rite Aid is a situation where it's a little bit of, Rite Aid was the general counsel and 3 other executives, I believe. The CEO, I think the CFO, and the general counsel. Yeah, the CFO. Criminal charges were also brought in this case, and there was a restatement because of basically all kinds of accounting shenanigans. And it appears that the CEO, CFO, and general counsel were a unit working on all of this. And again, you see the general counsel, the lawyer, stepping outside the role as a lawyer, and as the SEC would tell you, as a gatekeeper, and being sort of one of the gang in there. And my wife tells me I go way too far that way. But I guess I look for trouble so that I can avoid it. And what you see lawyers getting in trouble when they step out of that role of looking for trouble so they can help the clients avoid it, and they get in there and they're just a little too gung-ho to say, all right, we're can-do, we can get in here, we'll find a way. Well, everyone wants to do that. It's a great marketing thing, but it's not so good when you cross that line and when you get just a little too carried away and you stop acting as a lawyer and advising them and giving them the tough sorts of analysis and maybe unpleasant messages that you're forced to give them sometimes. Apparently in this case, the general counsel was instrumental in the fraud, helped create false emails, helped them recognize litigation settlement receipts in a period when it actually hadn't settled it yet. And apparently, I think the big one that I think they got him for was backdating severance letters for about 8 of the employees that got them lots of money, including himself. Again, in there just working as one of the gang, we're going to get this done, And when he was sentenced, I think he was 76, and he was sentenced to 10 years. And I don't know if that's still standing or not. That was in the last year, I think. But this was, and the CEO, I think, had founded the company, and apparently it was having hard times, and they just couldn't face the fact that the business wasn't going well. Now, we all know about this one, and I put this one up only as an illustration of, as we know, Mark Belnick, the general counsel, was acquitted on all charges. But I put this up because he did have to go through it. He got, along with lots of other compensation, a particular $17 million bonus. That the claim was that the board, that was not authorized by the company. The board had not approved the bonus. And since then, of course, we've got all kinds of new rules about executive compensation disclosure, actually proposed right now, that most companies in their proxies that are going on right, this is proxy season, are actually following most of the proposed rules. But even since then, we have rules that are in effect now about how compensation for executives has to be determined by independent directors and so forth. But these are the cases, these are the headlines that led to a lot of these rules. And so we've got this questionable area about whether his bonus was approved properly. And he successfully argued that he thought the CEO had the power to grant him the $17 million bonus. I guess no one knows if he did or not, but apparently the jury thought he did, and so he was acquitted. But again, it's a situation of too close, lawyers being too close to the clients. Now I know that's not what the marketing department would tell you in the law firm, not in our firm. But if you're not acting as a lawyer, you're crossing those lines, and for any number of reasons. You're not representing the organization. You're acting as a business person in the organization. You're not acting as their lawyer, and you may even give up your clients' reliance on legal counsel defense. There's some headlines about that, and just recently. So again, I think all these illustrate this crossing the line and sort of wanting to be, as I had a boss once years and years ago when I was a young lawyer who would remind me every once in a while. I guess he thought he saw me doing this. He said, you ain't here to make friends, when we would be negotiating a deal. And he would remind me, I don't care if they like it or not. This is what we're doing. Computer Associates is a situation where you had, again, massive accounting fraud. CEO was involved, Sanjay Kumar, and they hired Wachtell to come in and do an internal investigation. And, of course, it was a very thorough internal investigation. There was only one problem with it, and that was that apparently the executives involved, and maybe even including the CEO, were orchestrating the investigation from the other side, unbeknownst to Wachtell, and carefully sort of choreographing the cover-up. And so when Wachtell interviewed the employees and the executives and so forth, they were all lying. They'd all gotten their stories together, and they were all lying to Wachtell. It was all turned over to the U.S. Attorney's Office, and they hit him with obstruction of justice charges. And I think there were maybe 4 of them that were charged, and I think 3 have settled. I think 3 have settled with the government on those charges. But here's a situation, not for anything that the lawyers did, but illustrating this sort of deputization of lawyers by the government here. I think the government was very clear. You absolutely knew that this was one. Let's do an internal investigation, and who better to get than Wachtell Lipton, who can argue with that, and we'll get them to come in, and we'll tell them what we want them to hear, and they'll present this report that says everything is fine, and we'll be off the hook. Clearly, these people knew that this report was going to be turned over to the government, or very likely to be turned over to the government, so when they lied to the Wachtell lawyers, they were lying to the government. It doesn't sound like a stretch to me. So to sort of wrap up and get everybody to the beer on a Friday afternoon, how can you stay out of the spotlight? How can you avoid doing these things? Obviously, you got to know what you're doing. It's not clear that the bond counsel in the first case really knew what the requirements were to issue this bond counsel opinion. It's just really not clear that he did. He seemed to have some familiarity with it, but not quite enough to really do the job. And then you've got to be able to tell the client what they don't want to hear, and don't look for ways to become unpopular, of course, but you've got to be able to do that if you need to do it. And I guess you just have to hope that in the end, whether it's your employer or your client, that's hired you as an outside lawyer, that they will realize you're doing something to help them, whether they like the medicine they took at the time or not, and that in the end that they will realize that you've done something to keep them out of trouble. And then we hear a lot about tone at the top with compliance and with Sarbanes and with everything you see now and the sentencing guidelines. Tone at the top. Well, if you're an in-house lawyer, if you're the general counsel, or if you're the head of a group of lawyers inside the company, you can change things with the tone at the top. Whether you're a lawyer or a business person, I read something recently that said that people need to think about setting a tone or setting an atmosphere where people realize that getting ahead means not cutting any corners and doing the right thing. And you can see it. And if you have a group of people, you can see if someone gets rewarded for making the numbers, and everyone in that room knows how they made those numbers or has a pretty good idea. And if that person cut just a few corners and got there just a little bit edgy, people in the room think to themselves, okay, that's how I get ahead. That's how he or she got to be the supervisor of the Southeastern District or whatever they are. And if they see that same person being brought up in front of the room and given a good talking to in front of the whole group for not supervising records or whatever, then that sends the same message. And so the lawyers can do the very same thing. And even as outside counsel, you can do it for the inside lawyers. You can try to keep them on the straight and narrow and not let them get too close to the business side and lose what they're doing, being lawyers. And then the board. While we don't represent the directors, we represent the organization, and the organization, the closest thing we have to the sort of physical embodiment of the organization really is the board, as far as directing what goes on. And so boards they're more awake than they were 3 or 4 years ago, but some of them are not quite as awake as they ought to be, and some of them still don't realize what it is they need to hear because, as you've just had absolute evidence, this is not the most riveting stuff. And so boards don't want to sit through board meetings and hear it. They don't want to do it. I've tried so many times to say, let's have a governance half day or whatever, and they look at you like you're crazy. Of course we're not going to do that. We're busy. We know what to do. But you've got to force it on them. You've got to make them sit down and listen to what it is they need to hear. And all of this puts you in that gatekeeper function. Stay in the gatekeeper function. Don't become sort of one of the gang. And I found this quote just the other day, and I thought it was perfect for staying in that gatekeeper function. So I'll take any questions if anyone has any. Yes.
Just mention one thing. I don't know how many of you have seen the documentary that came out about Enron last year. It's called Enron, the smartest guys in the room. If you have not seen it, particularly for the students in the room, you need to see it. It'll scare you to death because that's the world, kind of the corporate world that you can end up in. It's an excellent, it's riveting, and there are big segments in it in which they interview the reporter at Fortune magazine who cracked all this open and found out that they were not making any money, and that people were just agreeing they were going along with everyone else, and it was an enormous fraud.
Where did you find that, Don?
You can get it. It just came out on DVD very recently, in the last month or two. It's called Enron, the smartest guys in the room. And it's about Kinley and Skilling and Pastel, all of them. It's just a riveting movie, particularly with the trial going on right now. It's great. You really should see it.
Well, thanks for that, man. Judge Everett, I think we presented a program that meets your standards. I'm very grateful. But I want to thank all of you. This conference really doubt the participants wouldn't be somewhere with it. Well, thank all of you. Again, you're invited to the Birdman Lounge, and I look forward to meeting you in the bit. Thanks.